Okay, so I'd like to let you in on a secret. Every so often at work, over the last 10 years that I've been working in law, I get an email, and it's a particular kind of email. It starts out very nicely, and then it includes the 10 words which I think are more powerful than any other 10 words in contemporary culture. Those 10 words are, concerns have been expressed about what you've written online. And I like to think of that as the kind of contemporary version of, I made him an offer he can't refuse. A sort of slightly threatening, menacing ultimatum. And when I read these emails, I thought, what could they be talking about? I mean, I sometimes tweet really bad jokes. I haven't said anything racist or homophobic, I don't think. But always it's what I've written about the Human Rights Act, which is extraordinary. And it made me realise that really our discussion on human rights, and particularly this one piece of new Labour legislation from the late 90s, has become very, very confused. On the one hand, you have human rights proponents, people who believe in human rights and the human rights law, that say that effectively repealing this piece of legislation will turn our country into a tyranny, and we're on a slow slide to sort of a dictatorial politics. And on the other hand, you have critics of the Act who claim that basically it's responsible for everything that goes wrong in our society. It's why we can't deport criminals, it's why criminal trials go wrong, it's why rapists get off, blah, blah, blah. And of course, both of the sides of this debate are completely wrong, and get wrong what is at stake. And so what I wanted to start by doing today is introducing a new way of looking at this discussion by delving in a little bit into the intellectual history of human rights. I'll then try and convince you that repealing the Human Rights Act is at least bearable. If you can agree with me that it's bearable, then I might be able to go one step further and convince you that it's a good idea. And then, lastly, I'll try and argue what you would replace it with, which I think would be far more powerful. Okay, so quickly, a quick divulgence into the history of human rights. I wrote a book about the Human Rights Act some years ago now, and Alistair's absolutely right, it's completely out of date, don't buy it. But in writing that book, I was drawn to the scholarship of a man called Samuel Moyn, whose work is certainly still worth reading. He's an intellectual historian from the University of Harvard. And the insight that he gave me in looking at this issue was to identify what he calls the continuation fallacy. The continuation fallacy is that effectively there is a continuation between the ancient idea of rights, running from the Magna Carta, the Bill of Rights, the British Bill of Rights, right up through the French Revolution, the American Constitution, and resolving into our current human rights framework embodied in the Human Rights Act and the European Convention on Human Rights. And Moyn's point is effectively that this is completely wrong. It's completely wrong to say that there is some continuation between those rights and the rights we have today. And the important thing to recognise is that in the course of the 20th century, with the development of contemporary human rights law, we saw in the place of what we might call civil liberty, or what the French call droits de l'homme, the rights of man, we saw instead the introduction of a transnational framework of law, which allowed transnational institutions to curb the behaviour of democratic states. Now that was very, very different to what had gone before, because in the lead up to the 20th century, for hundreds of years, the process of fighting for increased freedom was a process of democratically pushing back against the power of the state. With the advent of human rights law, we can go into the discussion the kind of history behind the founding of our contemporary human rights laws. But what took the place of that process of pushing back against the state was the introduction of judicial power to curb the power of democratically elected governments. And that was a very different thing. It was a very big break from what had gone before, and it effectively delegated the duty of defining important freedoms to a judiciary. In the case of the European Convention on Human Rights, judges of the European Court of Human Rights, and also in the context of England and Wales, the introduction of the Human Rights Act allowed the Act to be enforced in our domestic jurisdiction. So the meaning of these rights became the subject of judicial consideration and enforcement. Now, that means that the judiciary have obtained, in the course of the passage of the Human Rights Act and the period in which it's been enforced, I would argue that they have obtained a significant power to set and control the ambit of our freedoms and particularly what these freedoms mean. And I think that's actually very dangerous. And I think we really underestimate, and supporters of human rights underestimate, how dangerous it is to delegate the meaning of freedom to unaccountable judicial bodies. And I think one example we have to talk about, because it's so prescient, is the situation in the States with regards to Roe versus Wade. Because you can be extremely critical of the decision in Roe versus Wade, but underpinning the reality that now pervades in American law is the fact that states in America have not passed laws to enshrine the right to abortion democratically. Roe versus Wade was always a sticking plaster to the fact that the debate around abortion had not been democratically won. And I think we need to take Roe versus Wade as an example of what can happen when we trust the judiciary to protect important freedoms. So taking a step back again into history, in order to understand better what is at stake here, I think we should go back to when the meaning of human rights was, I would argue, most energetically debated. And that was between the two 18th century intellectuals, Edmund Burke and Thomas Paine. Paine was a radical who advocated in favour of the French Revolution, and advocated in favour of the revolution on the basis that he saw it capable of enshrining certain inalienable rights. And for Paine, these rights were capable of existing across history and were capable of existing through different societies. So rights would persist no matter the society that happened to be embodied at any particular time. And human rights proponents often rely on Paine and point to Paine as someone who embodied the idea that no matter what kind of society you are in, there are some certain things which remain fundamental and that can't be intruded upon and would always be wrong to intrude upon. On the other side of this debate, we had the English conservative Edmund Burke. And Burke wrote effectively what was a response to Thomas Paine in his book Reflections on the Revolution in France. And for Burke, it was meaningless to talk about freedom without talking about the historic and social institutions which can protect freedom. It would be irrelevant to talk about rights in the abstract. You and I don't have any rights in virtue of us just being human. Rather, we have rights in virtue of the society that we happen to be in, the community that we happen to be in, and the capacity of that community to respect our freedoms. And in a particularly nice turn of phrase, Burke said that he cannot give praise or blame to anything which relates to human actions in all the nakedness of metaphysical abstraction. In other words, we need institutions and traditions to maintain the very liberties that Paine was talking about. Now, I think today what we need to try and do is strike a balance between these two positions. We can choose to believe that human beings are deserving of certain basic freedoms in virtue of being human. That seems to me a perfectly rational and reasonable conclusion. And particularly, we proceed on that basis in the West. We don't put people to death anymore. We generally believe that people should be able to think and say what they like, although we can come on to debate how true that remains now. But nonetheless, we can also recognise that any abstract rights will mean very little if they're not reflected in the society and the institutions and the manner in which we live with one another. And I think landing between those two positions is where we need to end up. Importantly, we cannot just secure abstract freedoms by writing them down in a law, whether it be the Human Rights Act or the Bill of Rights. We have to actually live them. We have to actually live freedom. We have to organise our society using these freedoms as principles. So perhaps you're saying this still sounds a little bit like Burke's metaphysical abstraction, and that's fair enough. So how do we get there? Well, let's start by looking, if I've got time, and I've got about... 3 minutes. Oh, great, I've got 9 pages left to go. So. Jesus, okay, we'll skip... Does everyone know what the Human Rights Act is? Because I can just skip that bit if that's appropriate. The point I wanted to make about the Human Rights Act is that fundamentally supporters of human rights have to acknowledge that the framework is undemocratic. And what do I mean by undemocratic? It means that the protection of individual liberty is delegated to an unaccountable and, in this situation, foreign judiciary. And a good example of this was the Rwanda policy. So you can debate the merits or not of the Rwanda policy. I don't agree with it. I think it's wrong. But I also think it's profoundly wrong that a judge sitting in Strasbourg was able to, with the single stroke of a pen, and on what we call an interim basis, meaning that he didn't consider the substantive argument, he merely recognised that an interim step, something that needed to be done straight away, so he took the step before considering the substantive merits of either position, effectively prevented a democratically mandated policy from being carried out. He prevented the flight from taking off. And that had the effect of not carrying out a policy which, whether you agree with it or not, was democratically mandated. And I think this is a good starting point for recognising why repealing this act is a good thing. Because if you believe as a principle that democracy has to have as much sway over politics as possible, then you have to reject human rights law, because it necessarily passes control over important political matters to an unaccountable body. And human rights supporters actually acknowledge this. They will say that democracy needs what they call checks and balances. And that's a fair position. And from that position, they argue, look at all these examples of the fantastic things that our human rights law have done. But what they also have to acknowledge is that for every success that these human rights laws have purportedly achieved, they leave behind a litany of failures. And I think what it ends up doing is preventing us from thinking seriously about the political situations that human rights law were designed to remedy. So again, I've skipped through a fair amount of what I wanted to say, but what's the alternative? Well, I think the alternative begins with the recognition that the real threat to liberty comes from statute law. It comes from law which is introduced by Parliament and by the government. And human rights law has very little power to control the passage of democratically mandated law. So we need to create a society which embodies certain freedoms as principles. So how do we do that? My suggestion is to create and foster a culture of freedom by removing the law and encouraging more free political interaction between citizens. So how would you replace Article 10 that purports to protect freedom of expression? Well, here are some practical steps. One, we could repeal any law which criminalises speech. We could publish prosecutorial guidelines for things like incitement and harassment, which, although may have a legitimate purpose, can be used to undermine people's free expression. You would fund public debates like this to encourage a wide spectrum of views. You'd make sure that debate was part of people's school curriculum, and you'd refocus civil education on tolerance and respect for personal opinions rather than on human rights and the meaning of the European Convention on Human Rights. The right to a private and family life. Well, our law intrudes on the right to a private and family life in a way which human rights law is completely powerless to defend against. For example, the most radical incursion on private and family life was the regulation of Investigatory Powers Act, which effectively allowed extensive surveillance by public bodies, etc., into people's private lives. And if you're worried about family life, Article 8 rights, then create, and it's particularly this right is used in the context of immigration, create an immigration system which doesn't separate families. Rather than relying on a judge to arbitrarily enforce a law in particular cases, have a look at the underlying problem, which is that we have an immigration system which is fundamentally inhumane, separates families, and creates bad outcomes. Final, absolutely final, I promise. If we were actually to approach repealing and creating law with those principles in mind, creating a culture which respects freedom, creating a culture which genuinely values freedom of opinion, freedom of expression, then this would actually have a far more fundamental effect on enforcing what we might call human rights than the Human Rights Act ever did. The Human Rights Act has fundamentally been a failure, and it's certainly been a failure in creating the kind of culture that genuinely respects freedom. If we were to reorientate our approach to the law and to freedom around basic principles, then it would represent a far more radical reorientation of our society than the Human Rights Act ever did, and it would create a society in which freedom and tolerance were lived parts of the world that we live in. And maybe at the least, this would mean me having more debates like this and fewer concerned people sending bitchy emails. Thank you very much.